Joining us now to discuss the legality of the president's actions is former U.S. Department of Justice official Peter Vincent. Peter, in your opinion, do you see an obstruction of justice case involving President Trump or his administration here?
Keir, it's clear that the former director and all, in fact, Senate-confirmed political appointees serve at the pleasure of the president. And the president, in this particular case, had the legal right to fire Director Comey. I don't see at this point yet enough evidence, let alone evidence that could be proved in a court of law, that the president himself, either through firing former Director Comey or through sending out a tweet or two, is obstructing justice or tampering with a federal witness.
Straightforwardly, is it legal, if it did happen, if it has happened, for the president to secretly record White House conversations?
What's interesting is that politically, it's obviously not a good idea given the specter of Watergate. However, federal law allows for one-party consent to record conversations either telephonically or in person, as well as the District of Columbia. Again, it is a one-party consent district. Therefore, one party, that is President Trump, could have legally recorded those conversations. Other states, such as the state of California or the state of Washington, are actually two-party consent states, and in those cases it would have required the consent of both former Director Comey and President Trump.
Where do things go from here in the question of whether there are recordings like that? Is it possible for some kind of investigation to demand to get hold of those recordings if they exist?
Absolutely, and I understand that there is a letter that's already been circulated by members of Congress requesting, to the extent that there are any tapes or digital recordings of those conversations, and perhaps any conversations conducted in the dining room of the White House or the Oval Office, that they be provided to Congress. In addition,
the president would have to hand them over, would he? He would have to hand them over.
Absolutely, and I would strongly suggest that he would in this particular case. You know, it's hard to know what the president was talking about in terms of recorded conversations. In this day and age of smartphones, it's possible that the president was recording something on a smartphone, which is relatively easy to do. We just don't know enough at this point, Keir.
And if you do it on your smartphone, does it make any legal difference?
Not to my knowledge. We are in an age when technology is developing so quickly that we really don't know how that particular case might differ from the old-fashioned sort of recording devices that we're all familiar with and which were, of course, at the heart of the Watergate scandal. I should point out as well that an obstruction of justice argument is awfully difficult to make in a court of law because it requires actually an intent, mens rea we call it, an intent to actually use information or to make threats in a way to actually obstruct justice. And we just don't know enough at this point.
Okay, former Justice Department official Peter Vincent, thank you for joining us.
Thank you,
President
Keir.
Trump preparing for his first